Foremost, Honorable Speaker and members of this House, it is not contested that there is no order, there is no conservatory order stopping Senate from considering the impeachment motion that is before you. There is no order by court injuncting or enjoining this House not to proceed with the business of the day. What the governor challenges or impugns is the validity or otherwise of the impeachment motion that is before you. I submit, Honorable Speaker, that the question of validity of the impeachment motion is a question of interpretation and is reserved for the judicial arm or branch of government at the opportune time. As my learned senior, Nyamoji, has already submitted, we have authorities in the submission that we filed in response, and this Honorable House has given rulings in previous matters, including the previous ruling in the impeachment, in the matter of the impeachment of the governor of Kericho County, that legislative processes that are before Parliament, the moment this House or Parliament is seized with a resolution by a county assembly to remove the governor from office, this House becomes irreversibly seized of that impeachment motion, and no order of court can stop this Honorable House from conducting its business. More importantly, Honorable Speaker, that position has been adopted not only by this Senate or this Parliament, but by other parliaments world over. We have authority in the report of the committee on the proposed removal from office of the governor of Embu County that the Senate becomes irreversibly seized of the matter the moment the Speaker of the Senate receives a letter from the Speaker of the County Assembly communicating the resolution of the Assembly to remove the governor from office. The committee went ahead, Honorable Speaker, to quote similar positions adopted by parliaments in other jurisdictions, including Ghana, in the Supreme Court of the decision there, Honorable Speaker, Sri Lanka, and the United States. Honorable Speaker, the position that has been taken by this House in previous impeachment proceedings has been adopted by the highest courts in the Republic. The Supreme Court, in the matter of the governor of the former governor of Embu County, Martin Wambora, and the Court of Appeal have agreed with this House, Honorable Speaker, that the judicial arm of the state cannot direct Parliament on what to do and not what to do. Therefore, it follows, Honorable Speaker, that at the opportune time when this Honorable House has conducted its proceedings, these proceedings will then fall before the judicial arm of the state. And at that time, the judicial arm of the state will have every opportunity to test the proceedings of this House for constitutional compliance. It is agreeable, it is common ground, Honorable Speaker, that the proper judge of compliance with the Constitution and the standing orders of this House and the statutes relating to the removal proceedings of a governor is the judiciary. The question or the point that is not agreeable by both sides is at what point can the courts stop an inchoate or an ongoing constitutional process that is before the legislative assemblies. The Supreme Court, Honorable Speaker, in the matter of Martin Wambora, had occasion to deliberate on this issue. And at pages 6 of our submissions, page 6 and 7, Honorable Speaker, you will find an exposition of what the Supreme Court said. The Supreme Court explicitly forbade, Honorable Speaker, courts from granting orders that stop ongoing proceedings that are before legislative assemblies. And to quote what the court said at page 6, in fact, it is at page 7, Honorable Speaker, no governmental agency should encumber another to stall the constitutional motions of the other. The best practices from the comparative lesson signal that the judicial organ must practice the greatest care in determining the merits of each case. So, the question that arises, therefore, Honorable Speaker, is while the governor impugns or challenges the validity of the impeachment motion, the validity of the court order that was given, which court order is the basis of the challenge that the governor has put up to the propriety of these proceedings, is also in question. The validity of that court order is in question because, Your Lordship, because, Honorable Speaker, the highest court in the Republic have affirmed what this House has stated on numerous occasions, that the judicial arm of the state, though it can intervene to stop or to check for constitutional compliance, that process before the Legislative Assembly should be left to run its full course, and at the opportune time, the judicial arm of the state can intervene to check the propriety of those proceedings. Therefore, Honorable Speaker, can a court, the High Court, and Honorable Speaker, Section 5 of the Judicature Act provides for the hierarchy of laws in our Republic. The Constitution is at the top. Honorable Speaker, the apex court in the Republic, as per our Constitution, is the Supreme Court. The Court of Appeal is next. The decisions of the Supreme Court, as per Article 163(5) of the Constitution, Honorable Speaker, are binding on the High Court. The same goes for the decisions from the Court of Appeal. The question, therefore, is, can this Honorable House be stopped by a court that has disregarded binding precedent? Can this court be stopped by a court that itself is lacking in jurisdiction? Our response or our answer to that question, Honorable Speaker, is that you should proceed unhindered, undeterred, and render a decision or a determination on the impeachment motion on the merits upon hearing the witnesses that are to be called by the respective parties. The danger, Honorable Speaker, is if this Honorable House was to terminate the proceedings at this stage, then, Your Lord, Honorable Speaker, it would set a very dangerous precedent. And that dangerous precedent, Honorable Speaker, is that all that a governor would need to do is to move to court and obtain an order either quashing the impeachment proceedings before they even begin, or stopping this House from considering the impeachment motion before it is even seized with that impeachment motion. And therefore, Senate would have abdicated its role as a defender of devolution. Senate would have abdicated its oversight mechanism in the removal from office proceedings of county governors. And therefore, Honorable Speaker and the members, as you deliberate on that issue, we sound that caution that whatever is established today will have an implication on future impeachment processes that will be brought before this House. On the second ground of the PU, Honorable Speaker, counsel for the governor have referred to affidavits by the clerk of the Assembly and affidavits by the AP commander, Isiolo County. And all these affidavits, Honorable Speaker, have been referred to persuade you that there was no sitting by the Assembly on the 26th of June 2025 when the impeachment motion was approved by the County Assembly. The question that arises, Honorable Speaker, is whether the contents of those affidavits can established, whether the contents of those affidavits are to be believed without testing the evidence of those witnesses under oath. So the way I see it, Honorable Speaker, is that the governor is asking for a full trial. By making a reference to those affidavits, it must be taken that the governor concedes that that PO is not a pure point of law, is not based on a pure point of law, that can be canvassed by counsel without reference to affidavits by witnesses. The reason we file affidavits before you, Honorable Speaker, is to give advance notice to the other party, so that the other party can prepare on how to test the truthfulness, the credibility, and the veracity of those witnesses when they take the stand to give evidence before this House. So, Honorable Speaker, the contents of those affidavits, the depositions that are contained in those affidavits would have to be tested by way of cross-examination of the witnesses for this Honorable House to make a conclusion on that question as to whether there was a sitting. The same goes for the answer that is impugned by the clerk of the County Assembly on oath. With regard to the question of further on that question of the alleged forgery of the answered, all the counsel for the governor has done is to make reference to an affidavit by a witness. Counsel was submitting on what is supposed to be a preliminary point of law. It is no longer a preliminary point of law, Honorable Speaker, if counsel does not restrict himself and now, takes the posture of the witness and testifies on behalf of a witness on what they have deponed under oath in an affidavit. At the opportune time, Honorable Speaker, we will be praying to cross-examine those witnesses in order to establish the truth. The further question that arises, Honorable Speaker, as I conclude, is the clerk of the Assembly under the County Assembly Services Act is required to render expert non-partisan advice to the Speaker and to the House on procedural matters and all other matters that are before the House. We will be craving for an opportunity to cross-examine the clerk on all the issues that counsel has alluded to in trying to persuade you, Honorable Speaker, and the House that you dispose of the issue of whether there was a sitting and the issue whether there was forgery of the answered at this preliminary trial. A mini trial that the governor requests for, a trial within a trial, is not necessary, Honorable Speaker, if the issues that are to be canvassed during that mini trial can be established in the full trial. Or that the issues of the sitting of the Assembly, the issues of the alleged fraud, the alleged forgery, are matters that belong to the full trial. It is for the governor to prove that indeed there was forgery, because he's the one who alleges there was forgery of the answered report and that there was no sitting. It is for the governor to prove through evidence that is going to be tested by way of cross-examination at the trial. Therefore, Honorable Speaker, reducing that issue, and it's a very germane issue, the issue of the sitting and the alleged forgery, to a matter that can be handled at this stage without leading evidence, is not only inappropriate, but against the best interest of justice, because the County Assembly will not have the opportunity to cross-examine the witnesses that are being called, and those affidavits have been referenced to by the Governor's Council in making that preliminary point. In conclusion, Honorable Speaker, it is only after a lengthy and a drawn-out hearing in the main trial that all these issues that are couched as preliminary objections can be sufficiently addressed. Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged. The court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted. Can a court whose jurisdiction is challenged and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature, the jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court that is required to set aside that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Muriuki.
Honorable Speaker, esteemed members of this House, my name is